Yeah, if Bree wants to continue to talk about, I mean, I can add her to my list tomorrow of who's getting charges pressed on her. It ain't nothing but a thing. I know she thinks that I can't afford a dog. Again, I can. I just choose to spend my money on a child. But if she wants to continue to provide false information about me, I can definitely have my attorney add her to the list. So keep it coming. And Bree, BTW, you may want to talk to your attorney. Your attorney is who made all of this public record. Yeah. So that was money well spent, just like the dog that did you see your dog chewed up your sandal, by the way? Crazy thing. My grandkids don't chew up my shoes. And ain't that some shit? I could have the most expensive shoes in the world. My grandkids ain't going to chew them up. And I get them every day. Get to see them every single day. So random and weird. Good purchase. Anyways, back to reading your attorney's emails. Hold on. It could get good. As I was saying. So this is from John's great attorney. It says, "Hi, Lindsay. Unfortunately, my client is adamant that the visits occur at a monitoring facility at least for the first month." Funny, I literally just said that. Your client took the child and refused to return him over to numerous law enforcement officers. Factual, and streamed it all. So that's not lying. That's facts. If she is not deterred by police officers, we certainly cannot trust her to not abscond with the child from a professional monitor. Exactly. And she has stated on multiple occasions that she would do that. Again, I personally feel like she was being sarcastic, but nonetheless. There are kidnapping prevention orders in place. A supervised visitation facility is essential, and the orders allow my client to select the monitor. Please see the attached. I will call you tomorrow. Oh, there is more. So this is from Bree's attorney, going back to John's attorney. Yes, tomorrow at 12:30 p.m. for a call is fine. Respectfully, John doesn't get to modify the orders on his own accord. If he wanted visitation to occur in a visitation facility, he has certainly free to request that, but he didn't. You and I both know a professional monitor and a visitation center are two very different things. Under 7 in your attachment, the judge wrote professionally supervised, not professionally supervised, only in a visitation center. More importantly, all of your requests in John's second DVRO were denied except for the order to not AB. Baby W and Grandma aren't protected parties, and the judge explicitly wrote that the 324-25 custody and visitation orders are to stand. Those orders are for a mutually agreed upon professional monitor, not a visitation center. You're moving papers only requesting supervised visitation with dates, times mutually agreed upon by the parties, not that a visitation center be used. You alleged that Bree threatened to kidnap Baby W from the monitor, and the existing order for a professional monitor to be used in Dallas were still ordered to remain in place. In short, there's not short about this email. In short, you didn't request, and the judge never ordered for a visitation center to be used. John has no right to insist on that, as that's not the order. I'm a parent to a toddler. As a lawyer and parent, I understand the concerns with the allegations your child has made. I'll also say that I refuse to engage in the court of public opinion online and am trying to stay focused on the real court records, the real court orders, and the actual people that are involved here, not their online personas. What you're insisting on now is not remotely the order. If John doesn't like the 4 monitors my office found, we're happy to find more. Ultimately, he can send us a few names, and Bree and I can pick from that list.